Glad to be here, and thank you for the invitation to talk about a topic close to my heart, Canon Law. And to talk a little bit just about, what is the canonical tradition of the church, our church, most of our church, the Ukrainian Catholic Church, and what can we learn from that? So, basic questions, I think, really depend on these kind of answers. Who are the members of the Ukrainian Catholic Church? How does it function? And a lot of these questions we kind of discuss abstractly. We always have this question, what is Eastern Catholic theology? That seems to perennially arise. And today I want to take a bit of a canonical approach to these kind of questions, looking towards promoting maybe a clear ecclesial identity that looks at the bonds that exist throughout the Ukrainian Catholic Church. So we'll look at a brief introduction to canon law for those who might not be that familiar with the discipline. And then we'll look at some sources of canon law that are particular to the Ukrainian Catholic Church. Finally, we'll look at a few examples of church practice in order to see how the study of history might be able to guide us through a proper understanding of the church's discipline. So for those who might not know, canon law is most simply the rules and ordinances that govern the Christian community. And the word is not really unique to the Christian tradition, and indeed has its source both in Greek and in Arabic, and even the word exists in Hebrew, which is simply a standard of measure. Regulations that we now recognize as canons and call canons quickly developed in the church. Like any society or group, we had to get some kind of regulations into how we relate with each other. And by the 2nd century, we had manuals of conduct. One of the earliest of these, the Didache, has clear guidelines for liturgical practices and basic elements of church governance. So if we look at the study of early Christian texts, we see that the period of the early church, and really after the legalization of the Christian religion with the Edict of Milan in 313, that Christians found it necessary to organize themselves in a formalized fashion. Those structures that developed, and frequently as conflict in those contentious cases that emerged between Christians, needed more and more complex laws to govern those relationships. So what's the relationship between one preeminent bishop and another bishop, neighboring bishops? What's their relationship to each other? How do we receive heretics, apostates, schismatics to be reconciled into the church? These are the kind of questions that canon law attempts to develop and answer. And it has a number of purposes. Canon law certainly makes the hierarchical and organic structure of the church visible. The church is a mystical body of Christ, but it's incarnate and physical structures. So it, in that sense, provides good order to the church and defines how the church is to function. Canon law tries to address questions like how bishops are appointed, how the supreme authority of the church exercises his power, how you buy and sell property. This provides an expectable order in the church. It gives us a sense of organized religion. Canon law ensures the proper exercise of the sanctifying function of the church. What does that mean? So we try and make the conditions that allow the sacraments to be present. So, for example, we have requirements in canon law that the Eucharist has to be celebrated by a priest, that he has to use pure bread and wine and can't, for example, use rice crackers and grape juice. These ensure that the sacrament is real, that the grace of our Lord is present and offered in a definitive manner and available to aid the faithful. Canon law also provides rights, obligations, and consequently methods of resolving and exercising those rights in the church. And like any society, the church's members, whether physical persons or legal persons, we call those juridic persons, have rights and obligations. And these are articulated clearly in the canonical system. We have a system of trials and recourses and appeals that help us vindicate these rights. The church is firmly a hierarchical society, and there are occasions where maybe someone superior does not function according to the norm of law, and one could take recourse to a higher superior. We can also vindicate our rights through various trials. Finally, canon law attempts to provide structures that sustain and direct the church's initiatives. These structures are defined and directed in canon law. For example, a parish or a diocese or an eparchy has to have certain structures to function. If the pastor or the bishop wants to do something, he sometimes has to fulfill certain criteria, and canon law governs this. So where do we get canon law from? Well, certainly the most fundamental source for all the church's law is Scripture, the New Testament. And the New Testament provides numerous clear instructions for Christian life. The Gospel provides instructions on topics like baptism, the Eucharist, marriage, the fact we have to support the clergy, church's judicial activity, and even, at points, relations with the state. St. Paul's writings offer even more guidelines for the Christian community, again including the payment of clergy, requirements for ordination, how to handle accusations against clergy, and even how to relate with non-Christians. Many of these scriptural norms will be taken into legal language in canonical collections. In one sense, I think canon law can be understood to be simply applied theology. As the church's history goes on, the canon law of the church begins to formalize. And certainly we have these ecumenical councils that create what we call the sacred canons, where we have, the word ecumenical comes from the oikoumene, the inhabited world, this idea of we have people present representing the various churches of the world and providing legislation for the entire church. And some local councils as well had special authority due to the fact that they were seen as having binding authority on all Christians. These ancient Christians that we call the sacred canons form the common canonical tradition, indeed, of East and West. And so if we look at canon law, a lot of the times it will deal with civil issues as well, at least in the Byzantine era. So for us as Eastern Christians, this is very important. So if we look at the Code of Justinian from the 6th century, the very first title has that the state church is Nicene Christianity. The very first, part of the civil code of law defines that Nicene Christianity is the state church. The 5th title in that same book decrees that heresies are to be suppressed. And if one looks at the first 20 titles of that book of civil law, the first 13 concern ecclesiastical topics. For Romans living in the Eastern Empire, in Byzantium, canon law was indeed civil law. And further redactions of Roman law, like the Eclogue of Leo III, maintained this practice. In fact, canon law and civil law were inseparable in Byzantium, and that was carried over into parts of the northern territories. That is what we sometimes call today as Rus. In the West, the canons of the ecumenical councils were taken up in a different way into various canonical collections and distilled through the writings of the Roman pontiffs. And as Eastern Catholics, this is important for us because that'll come back into our history in centuries. And this formed a genre of canonical sources that we call the decretals. They were gathered together in a book called the Corpus Juris Canonici. In the 20th century, these writings were, in the Catholic Church, codified into a single volume that we call the Code of Canon Law, the first of which was issued in 1917, the second in 1983. This process of codification reflected a changing reality of the Church in the modern world and the complexity of using gathered sources in the Corpus Juris Canonici in a logical manner. There was a lot of history, and you'd have to know where to look. You could have a topic could be in 50 different letters of the Holy Fathers, and you had to somehow try and find harmony between them. So it just got a little out of control. So one approach to that problem in the Catholic Church was what we call codification. So this was also inspired by nation states at the same time, which were completing legal codes. And so in the 20th century, we had the 1917 Code of Canon Law, the 1983 Code of Canon Law, and the 1990 Code of Canons of the Eastern Churches. Now, if we look at Canon 6 of the 1917 Code of Canon Law in the Latin Church, we hear that, among other disciplinary laws in force, if they are contained neither explicitly nor implicitly in the code, they have lost their force, unless they are in liturgical books. So with the introduction of the 1917 Code of Canon Law for Latin Catholics, Roman Catholics, the great volume of historical legislation, the Corpus Juris Canonici, no longer had any legislative force. It provided important interpretations, principles of law, and certainly is of great interest for legal scholars like myself, but it is not, strictly speaking, use. It's not really law. The law for Eastern Catholic churches, however, is incredibly different. Canon 2 of the Eastern Code reads as follows: "The canons of this code, in which the ancient law of the Eastern churches has been most readily received or adapted, are to be assessed chiefly by that law." That the ancient law is to be our lens of interpretation of the modern law of the church. And when the Eastern Code came into effect, the following changes existed. Number one, all common and particular laws abrogated that are contrary to the canons of this code, and all customs are revoked that are reprobated by the canons of the Code, that are either contrary to them and neither centenary nor immemorial. So really, it was only those things that were directly contrary to the prescriptions of the Eastern Code, which is not a lot of things that we have that would actually be contrary to the prescriptions of the Eastern Code. The Eastern Code only governs things that are common to all of the Eastern churches. It's a different sort of text. The Eastern churches are very different from each other. Even, for example, Armenians don't use leavened bread, right? They're Eastern Catholics and use unleavened bread. So we can't even have a canon in the Eastern Code saying that we use leavened bread, right? But that can't exist in there. It's really only those things common to all the Eastern churches, which would be those things, for example, pertaining to the supreme authority of the church, things related to how the Synod of Bishops functions, especially a lot of monastic life. On trials, we have one procedural law common to the entire church, which makes things a lot easier, as you can imagine. So that historical law of the Eastern churches remains in force entirely, as it does not conflict with the Code of Canons of the Eastern churches that was promulgated in 1990. And as I mentioned, it forms an important interpretive lens. So the question needs to arise, well, what exactly is this historical legislation? In the context of our current discussion, what are the sources of law for the Ukrainian Catholic Church? And certainly that historical legislation, as received by the Christian East, was the normative, those ecumenical councils, the sacred canons that I mentioned, that were common to all the Byzantine churches. These are really three types of canons: the canons of the ecumenical councils, the canons of the regional synods determined to have ecumenical weight, also by the ecumenical councils, for example, certain synods from Africa and other places, and the canonical writings of certain church fathers that were determined to have ecumenical weight, also by the ecumenical councils. These different sets of canons were taken up in various collections that were organized by commentators. For example, the Nomo Canon in 14 titles by John Scholasticus, and a Slavonic translation created by Saint Methodius the canonist. Maybe people don't know Cyril Methodius. Methodius was a canonist. Cyril was a philosopher. These texts were collected into these various collections, and given the expense of books prior to the development of printing, often we would put different short texts together in a single volume that made it worth binding together. Jason, who's sitting at the back left there, binds books, and it takes a little bit of time, right, and a little bit of effort. So if we have more makes it worthwhile, it can be helpful. And among these collections were a series of collections called the Kormchaya Kneha, that contained ecclesial legislation, epistles, and sermons, Byzantine secular law even, that was taken up into the context of Rus, and native laws that emerged in the parts of the world that now are Ukraine and Russia, such as the princely statutes, what's called the Russian law, the Pravda Ruskaya, or maybe the Rusin law. You can't scratch out an S, sometimes. You get that Russian mustard, I always scratch out one of the S's. It's Rusin mustard, And because of the nature, this was before printing presses, we have different redactions of these texts, some of which are regional, some of which are, there's different textual traditions, right? Some just have come through different sources. So one of them, the Ephraim Redaction, which we don't have the original of it, was, we know, composed outside of Rus, probably for southern Slavs in the 10th century. This version, we know, was in use in Kyiv and other parts, and the oldest extant copy that we have is from the 12th century. Father Zuzek, who wrote in the 1980s on this topic, found 5 manuscript families of this textual tradition. We won't get into the real details, but just to say that there's a lot of variety existing. And how does that variety manifest? Well, what canons are contained there? Which civil legislative texts are contained there? Different context is in there. The second is called the Serbian Redaction, which is attributed to Saint Sava of Serbia, who was in the 13th century, 1219 to 1233. He was archbishop, and that was based on more current Byzantine material, drawing especially from canonical commentaries of Zonaras and Aristenes, who were late Byzantine legal theorists. A copy of this text, we know, was sent to Kyiv from Bulgaria at the request of the last pre-Mongol metropolitan in Kyiv, Cyril II. Now, a number of copies of that text have survived, and the earliest dates to 1284. Now, this redaction was declared to be the official collection of the Church of Kyiv in 1273, And this used the Serbian collection in consultation with this other textual tradition that they knew about already in the 13th century, the Ephraim collection. And that finished product is known today as the Russian redaction. Some parts of Ukraine did use that Serbian redaction, but the so-called Russian redaction is characterized by two phases, both the original 1273 and later texts. You can maybe say that there's common content, though, that are kind of interesting, and that would be the canons of the ecumenical councils, canonical answers of Metropolitan John the Prophet, the questionary of Kierik, the decrees of the 1274 Synod in Kyiv, the charter of Metropolitan Maximus, a letter of a so-called Elias of Novgorod, a Metropolitan John had a letter condemning the use of unleavened bread, requiring the use of condemning the use of unleavened bread, statutes of Saint Volodymyr, and the statutes of Yaroslav. The Northern redaction, which we figure originated in Pereyaslav, came to contain additions including the Ruskaya Pravda that was first contained in the 13th century. So it's kind of interesting to study these texts because you can also look at it from a civil law standpoint and look at the development of culture. And a couple years ago, I was still a student, so it was more than a couple, I guess, probably about 10 years ago, here at the University of Toronto, there was the International Society for the Study of the History of Canon Law had a meeting here. And one of my professors, Father Kowal, came here. He's an oblate from Eastern Poland. And he told me there were hundreds of people here, and he was the only canonist. Like, they all are medievalists, historians, whatever, studying the history of canon law. And there's incredible things you can learn from studying legal history. You can see how Christianization, for example, played out. In Rus, we had this tradition of the blood vengeance, where someone died in your family, you could do the eye for an eye, basically. You could kill someone in that other person's family, you could get that revenge. And you could see how that phases out in terms of Christian history, and that kind of reflects the Christianization of Kyiv and going north. So it's a very interesting thing to study. So the Koronchaya Kneha forms one big textual tradition that would have existed in the Church of the Union of Brest that was really formative to their experience. For us as Eastern Catholics, we certainly have other documents that come and are important sources of legislation for us. And certainly the documents of the Roman Pontiffs. The Roman Pontiff in canon law, we call him the supreme legislator. He is able to legislate whatever he would like. Issues certain documents that govern the life of all Catholics, including Eastern Catholics and Ukrainian Catholics. And certainly the penultimate one of those would be for us today the Code of Canons of the Eastern Churches. As I mentioned, this document provides the general framework for the functioning of our church. It defines and limits the powers of the Patriarch, the Synod of Bishops, the Eparchial Bishop. It defines how parishes are established, modified, provides norms for trials. It regulates financial transactions. It provides prerequisites for ordination of clergy. The Eastern Code, though, respects the principle of subsidiarity. It provides and indeed requires particular law to be issued by an individual church. An individual church we often call a church sua juris, a church of its own right, an autonomous church. And so, for example, as I mentioned before, there's no norm requiring leavened bread because that's not something common to all the Eastern churches. There is only one canon on mass stipends, or so-called mass stipends, on liturgy offerings. What can the priest receive for the celebration of the divine liturgy? Whereas if you look at the Latin Code, there are 14 canons very precisely defining the rules on this sort of thing. So a lot of these things are entrusted to particular law because the Synod of Bishops should have an understanding of the needs of a specific church, right? The bishops of the Ukrainian Catholic Church should know what we as Ukrainian Catholics need and should issue legislation that reflects our needs. At least that's the intellectual hope, right? Then we can, maybe critically examine how that plays out, which is a different topic outside the context of this talk, but just to say that that's the idea of the legislator. There are certainly extra-codal decisions of the Eastern churches, too. Some of these could be historical. For example, we have documents that impacted Eastern Catholics. Etsi Pastoralis from 1742, Benedict XIV, governed many topics. So we might be familiar of it because it prohibited infant communion. But beyond that, it provided norms for the celebration of the sacrament of penance, anointing of the sick. It gave some sort of order to how matrimony was to be celebrated. We know until recently that there were norms governing the ordination of married men outside of the patriarchal territory, the traditional territory of an Eastern Catholic Church. Cum data fuerit in the United States, fidelibus rutenis in Greci ruteni ritus in Canada, quae solerti in North, South America, and Australia. Now, these prohibitions were in force until June 14th, 2014, when Pope Francis abrogated them. So just because it's not contained in the code, the point would be, it doesn't mean that it doesn't exist. So there's a lot of other stuff out there that you'd have to be aware of. One could also note in today's context that the Eastern Code, I've used mine a couple times, but the Eastern Code...
Give that to your bookmark.
Yeah. It's like a mark of honor, The Eastern Code has no prohibition, not a single prohibition, against a priest, or cleric for that matter, sexually abusing a minor. It is not contained in the Eastern Code. It is not a crime in the Eastern Code. However, such a norm could be found in the substantive norms of Sacramentum Sanctitatis Tutela issued by the Congregation for the Doctrine of the Faith. So we need to be aware of what else is out there issued by the Roman Pontiff, because much of it will be applicable to Ukrainian Catholics.
Well, like the Ten Commandments.
That also, yeah. Yeah, I know. But, yeah, which Pope put those out? So. We did talk about Scripture already right at the beginning, right? Yeah. And then we have our own internal decisions. So foremost amongst these would be the Synod of Zamość. We're celebrating the 300th anniversary, or maybe celebrating is not the right word. We're commemorating marking it, the 300th anniversary this year. And I'm told that there are several conferences going on the topic of the Synod of Zamość. And this synod came because the circumstances of the union had changed significantly from 1595, where we had the anti-union church emerged more in the eastern territories, and the western territories that had been anti-union were more pro-union, had accepted the union. And there were disputes about foreign liturgical practices. In response to these, Lev Kishka wrote to Rome in 1715 asking for permission to hold a provincial synod. The idea, his intention was to, quote, stop heresies, unify ritual matters, and abolish abuses in the church. He was especially focused on liturgical problems and simony. Apparently simony was a big problem at this time in Ukraine. Hopefully that has since ceased. The Holy See granted, I realize this is being videotaped, permission was granted to hold the synod in 1715, and it was convoked in August of 1720. The synod was interestingly not under the presidency of the archbishop, but under the presidency of the papal nuncio, Grimaldi. And this was, in fact, the last synod held for the entire Kievan metropolitan province until the 20th century. It lasted from 26 August to 17 September. This is an important synod because, not just the breadth of the material that it produced, which is quite extensive, but the decisions of the synod were approved in forma specifica by Pope Benedict XIII in 1724. Which meant that approving something in forma specifica means that the Holy Father grants it the legislative authority it means to be a law, properly speaking. So in Rome today, the congregations don't possess legislative power. We have legislative, executive, judicial power, just like in the United States government. The church uses the same terms. So a congregation has executive power, so it can make instructions, do appointments, stuff like that, but it can't issue laws. Only the Holy Father can issue laws, properly speaking. But he can approve something in forma specifica, which is what he did for these decisions. And in 1807, Pius VII confirmed that the synod bound all Ruthenian Catholics regardless of their location. So he expanded it, and this again reflected just the changing borders of the Eastern Catholic Church at the time. Now, the synod certainly is frequently criticized and even discarded, I think, for having introduced foreign liturgical practices into the Ruthenian Church. For example, the recitation of the Filioque clause in the Creed, so that would be the addition of "and the Son" with respect to the progression of the Holy Spirit. It admitted the non-sung celebration of the Divine Liturgy, the so-called Low Mass, and prohibited the administration of the Divine Eucharist, among other topics. Yeah, to infants, yeah. At the same time, it did address abuses. For example, it prescribed loss of benefice for a cleric who celebrated the Divine Liturgy with unleavened bread. So that tells you the kind of things that were happening in that part of the world at the time. It's all relative, I guess, right? The Synod also covered many administrative topics, which I think we're often less aware of, maybe. These topics include decrees on reform, decrees on the power of the metropolitan, powers of the bishop, decrees on the ability of a bishop to impose taxes, decrees on proto-presbyters and rural deans, decrees on pastors, parishes, monasteries, convents, decrees on temporal goods, decrees on simony, decrees on seminary formation, requiring seminary formation, decrees that identified feast days, decrees that regulated the veneration of saints and how reliquaries were to be treated. And it also maintained the right of having married clergy that was placed in the decrees of the Synod of Zamość. Now, I would say that many of these decrees remain in force until the current day because of those principles we mentioned at the beginning, that they haven't been explicitly abrogated by a later law. And we'll look at a couple examples of that. In some cases, there have been a later law, so that kind of provision has been repealed, but many of it would still be in place. And again, just as the fact, that they've not been repealed, but even in 1992, our Synod of Bishops of the Ukrainian Catholic Church explicitly indicated that the decrees maintained the force of law as they were never revoked by either the Roman Pontiff or a subsequent Synod. So we have, Zamość is a big one. We also have decisions of the Synod of the Ukrainian Catholic Church. So we probably know, or hopefully we know, our bishops go to gatherings at different periods of time. Metropolitan and Sheptytsky began organizing these, in fact, already in the 1920s. In the period after the Second World War, there were gatherings of the Ukrainian Catholic bishops in the diaspora. And when Patriarch Joseph the Confessor was exiled from the Soviet Union in 1963, he began to hold archiepiscopal synods that occurred from 1963 to 1973. Now, interestingly, the Holy See intervened, and beginning in 1976, bishops were forbidden from attending such meetings without the express permission of the Roman Pontiff. The logic being that the head of the Ukrainian Catholic Church possesses no jurisdiction outside of his canonical territory. That was the logic. And indeed, even when they would go, for example, to the Eucharistic Congress in Philadelphia, the bishops who were attending received a letter from their respective nuncios saying, "We know you're going to the Eucharistic Congress, and great, but don't think about having any of these meetings while you're there. You were not even allowed to do it while you were there." And that went until really St. John Paul II became Roman Pontiff, who did allow Cardinal Slipe to convoke synods. He said they should have prior papal approval, so I guess he would ask, and John Paul would say, great, and they would do the... So we had in 1980, where Archbishop Lubachevsky was appointed coadjutor to Cardinal Slipe, and then we had 1983, 85, 87, 89, and they have occurred yearly since 1992. Now, in general, each year the Synod of Bishops has issued legislation that is promulgated by the father and head of the Ukrainian Catholic Church. And that obviously has juridic weight for us as Ukrainian Catholics. We also have particular legislation for parts of the Ukrainian Catholic Church, something that's not common to all of us, but maybe to us in Canada or to people in Ukraine. A bishop even could issue law for his own eparchy. Bishop David has issued many laws and norms in the eparchy of Edmonton. Some, of course, have greater historical precedence, and we'll look at two examples of this. The 1891 Synod of Lviv, and for us in Canada, the 1914 norms of the Ruthenian Church. In 1891, we had a synod in Lviv that was the 7th provincial synod of the Ukrainian Catholic Church since 988, and was convoked by Archbishop Sylvester Sembratovich, who was Metropolitan of Lviv-Halych. This synod was also attended by the papal delegate, Archbishop Chiaska, who was prefect of the archives of the Holy See. Now, this was much like Zamość, concerned with dogmatic, jurisdictional, and moral disciplinary matters of the Church in the context of Lviv. However, these documents were not approved in forma specifica by the Roman Pontiff, like Zamość had been. They were approved in forma communi, which means the Holy Father recognizes them as decisions, but they are not given legislative force. So really, they're more like guidelines. They don't have that same legislative weight that the earlier conference did. However, this synod would have force in the Archieparchy of Lviv. I thought this was good timing in a sense because just last week there were some decrees that were coming out in Ukraine. Maybe you saw them on Facebook. Some people related. One was related to the celebration of the Presanctified Liturgy. There was another decree that came out from Lviv about raising their hands during the cherubic hymn. So there's still some of these liturgical questions that are being played out in the church today in Ukraine. And the Synod of Lviv, certainly, while maybe not having that binding force, certainly at least for us in Canada, did make its way into other legislation, or inspiration for legislation, and in a sense survives that way. For Ukrainian Catholics, we had the particular law of the Ukrainian Catholic Church in Canada issued in 1914. So within 2 years of his appointment, Blessed Nikita Budka, the first bishop for Ukrainians in Canada, convoked an assembly of all Ukrainian Catholic clergy in Canada. So they had a 2-day retreat in November of 1914, and then an assembly that took place in Yorkton, Saskatchewan. Bishop Budka had been authorized by the Holy See to issue norms for his jurisdiction, which was at the time all of Canada. He had a professor of St. Augustine Seminary here in Toronto, Father Radkevich, who was instructed to provide draft norms that regulated various topics of the life of the Church in Canada. Father Radkevich looked at local Latin legislation. He wrote to a number of dioceses to find out what they were doing so we didn't have disharmony. The Eastern Code says we should do that. We shouldn't, if the Roman Catholic parish charges $10 for a liturgy, the Ukrainian Catholic parish across the road shouldn't charge $40 for that kind of thing. We should have some consistency. Or if we have marriage impediments, they should be the same impediments in a territory, that kind of thing. So he drew on that Latin legislation, other things that had been issued by the Roman Pontiff, and even looking at the 1891 Synod of Lviv. There was a consultative process where all the priests were invited to take part in the decision-making process, so it's a great example of collegiality. They were all asked to give their feedback on the matter. There was a final draft issued by Father Radkevich and promulgated in January 1915. And in those matters that have not been abrogated, which is most of it, because our bishops in Canada have not tended to be prolific legislators, as a whole, as a group, which is not a criticism, just to say that they just generally have been theologians, not canonists. For most of us, this would remain the normative legislation to us in the state. There was an attempt in the 1960s to issue a new set of legislation, but it never ended up, that project was never finished. This is also important for us in Canada because the Synod of Bishops of the Ukrainian Catholic Church does not have legislative power for us outside of liturgical matters. They can issue liturgical norms for us, but non-liturgical questions do not apply when you're outside the canonical territory. Which is not to say we shouldn't follow them, not to say they don't have moral weight, but they don't, strictly speaking, bind us. The norms, I saw actually a copy of Eastern Christians in the New World there. The norms are in the back of that if you've never read them. They're very interesting, all kinds of things about the liturgy, about feast days, about what books a priest has to have in his library, about the housekeeper, that she can't be of particularly attractive if they want to have a live-in housekeeper, the kind of things that the fledgling Pilgrim Church was dealing with. And then the Ukrainian Catholic Church as a whole has issued its own common law, or a particular law called the Particular Law of the Ukrainian Catholic Church. As I mentioned again, we have in the Eastern Code this idea that every church should issue its own particular law. We need to reflect our own needs. And we could also have a jus speciale, which is something different. This has to be approved by the Roman Pontiff that could be incredibly comprehensive. So our church attempted to do this in 1992, where they tried to expand the jurisdiction of the Synod of Bishops universally. That was a request that was never actually responded to by the Roman Pontiff, so there was never a yay or a nay, it was just not answered. But certainly maybe we could say that the structures that existed in 1992 maybe were not as developed as maybe they are today. We're just coming out of the underground and that kind of thing. So there might have been a prudent reason to wait on that, and maybe that's something that could be revisited. But to say that the Synod of Bishops is competent for making laws for the patriarchal church. And as I mentioned, this is restricted for most things to the patriarchal territory. We've had 3 editions of particular law in our church. There was a first one that was very brief, issued in 2001. A significantly revised one, issued in 2015, that was approved for a 3-year period. And a slightly modified version of that one that was issued in 2019. Now that particular law provides many liturgical norms, especially addresses who can be ordained a priest, who can be elected the major archbishop, provides specific norms for the functioning of the Synod of Bishops, and is really an important source of law for the Ukrainian Catholic Church. As I've mentioned, though, there is a question as to its applicability outside of the patriarchal territory. People like Ferris would say you can just ignore it. It has no effect here. So even the particular law, however, does not address all the topics that are issued in a more comprehensive document like the Code of Canon Law for Roman Catholics. As I mentioned, for example, Mass stipends, almost nothing there. Liturgical, obviously, because of the nature of the liturgy differing between the churches through years, very little is in there. The Eastern Code is really just what needs to be in there. And one example that we could interestingly look at, I think, is the question of infant communion. In our church today, generally infants are communed, but certainly that was not the case 50 years ago, for the most part. We know that the church in Ukraine, following Byzantine practice, certainly would have communed infants according to Greek usage, and the 15th century book of Canons that circulated in the Cave of Metropolia indicated that baptism even was to occur prior to the divine liturgy, so the child could be communed. Now, within the text of the Rite of Chrismation in 1646, the Trebnik, published by Petro Mohila, who was not in union, there were instructions on how to commune the baptized at the divine liturgy. So generally, we would say that probably so close to the period of union, we would have had the same liturgical practice in both the pro and anti-union churches in general. Certainly within the early anti-union polemical writings that existed after the Union of Brest, there were no accusations, at least at that time, of Latinization. So it seems to be a reasonable conclusion that we were doing the same thing. And even Paul V in 1615 told the church in Ukraine that they were to maintain their ritual tradition and not adopt any Latin practices. We could say, though, that probably since he wrote such a letter, there must have been some funny stuff happening already. Now, we know, as I mentioned very briefly, that the Synod of Zamość addressed the issue of infant communion, and the discussion of this practice began with an examination of the Eastern, quote, custom of admitting infants and children not having the use of reason to the sacred Eucharist. And that was because the Eucharist was seen as having the power to maintain life of spirit, to strengthen much, and to preserve. The Synod then decreed that not only are children, and we're talking about infants here, under no obligation to receive the Eucharist, but also decreed, quote, the Holy Synod establishes, out of consideration of reverence for so great a sacrament, hereafter to withhold those mentioned from Holy Communion. If they are deprived without having the power for scandal, they should not be admitted before they themselves have been diligently examined, instructed, of the years of reason to be ascertained, in order that they have the power to discriminate the body of Christ. The idea that the kids should have some knowledge that this isn't food, it is the body of Christ, which in the Latin Church has generally been associated with this idea of the annus discussionis, the age of reason, where you're able to tell this apart, and that was the logic behind it. So that legislation from Zamość really determined the sacramental practice of the Ukrainian Catholic Church for centuries to come. Metropolitan Andrei Sheptytsky did address this question in some limited way. Now, he had great efforts to publish new standardized liturgical service books, but the topic of infant communion was neither in the 1929 Reformed Service Book or the pro-Latinization, obviously not in the pro-Latinization book issued in Zsokva in 1929. Sheptytsky, however, did issue instructions for his priests to offer the Eucharist to Orthodox infants during the Soviet period, which is interesting. Responding to a request as what should be done when communion was approached by the Orthodox faithful, Sheptytsky said, I believe the child should definitely be communicated. And in that letter, Sheptytsky offered a brief history of the Latin practice of First Communion. And he mentions, interestingly, in that letter that among us, in Ukraine, the custom was virtually non-existent. And indeed, in some areas, it is barely being introduced now. So even in parts of Ukraine, in the Soviet period, so the 1940s, this idea of First Communion was still just kind of emerging. Sheptytsky adds that in our church, the age at which a child receives communion should be brought closer to baptism, and this should reflect the practice of the faithful. So I think his approach, which is a very pastoral one, is always not to legislate, but to guide, right? To try and encourage, to teach, and bring the practice to where it should be. The issue of perceived inferiority compared to the Latin Rite is obvious within the text, because Sheptytsky uses Roman Catholics in Germany as an example. Hey, the Roman Catholics in Germany are doing this with kids as young as 3. So maybe we could do that too, right? Like he exalts this kind of practice, which is an interesting path of argumentation, I think. Sheptytsky argues that if caution is taken towards the gift of the spirit of the promulgated legislation, Zamość could still be followed. Obviously, he's not able to dispense from papal legislation. That's the problem, right? But he can say, well, there's a concern for profanation. We can still reflect that concern in a context that's true to the law, but also better reflects our Byzantine traditions. And this was also a change from Sheptytsky's own 1905 position that First Communion should be 2 years after their first confession, after they've gone to confession 7 or 8 times. Now, the 1952 Trebnik issued by Rome offered, again, no direction on the content of infant communion. Now, it's interesting that the 1915 norms of the Ukrainian Catholic Church in Canada, or the norms of the Provincial Synod of Winnipeg in 1962 that were never promulgated but were written, neither one of those recognizes Zamość as a source of law for the Church in Canada. However, both of them repeat the norm of Zamość prohibiting infant communion, that they need to have an understanding of the Eucharist prior to reception. The 1915 norms cite the decree of the Council in 1905 that we need to have the age of reason. And the 1962 norms reduce the age to 7. So we have 7 now. We're all usually associated 7 with the age for communion, but that's really a 20th century innovation. They were trying to promote reception of the Eucharist in the Latin Church, so it was lowered. Now, this changed definitively with the Roman Pontiff's promulgation of the Eastern Code. And if we read Canon 697 of the Eastern Code, it says, "Sacramental initiation in the mystery of salvation is perfected in the reception of the Divine Eucharist, and thus the Divine Eucharist is administered after baptism and chrismation with Holy Myron as soon as possible, according to the norm of the particular law of each church sua juris." So this practice was seen as belonging to the proper tradition of the Eastern churches, but again deferring to their own proper hierarchs, for better or worse, to make a decision in this matter. The Chedus who created this norm in the Eastern Code was actually chaired by Archbishop Marusin, who was a Ukrainian Catholic bishop. And he said that they clearly did not overlook the issue as important as communion of the neophytes, but felt that they had to restore the ancient discipline and composed a new canon permitting the practice of infant communion. It's their clear intention that children would go to communion from this. And so in response to that call for a restoration of a single and integrated act of sacramental initiation, the new particular law of the Ukrainian Catholic Church does reflect that discipline. Maybe it took them kicking us to get in the right direction, but it worked, whatever. And it says that the sacrament of Christian initiation is completed with an individual's participation in the Most Holy Eucharist. And this is why, together with baptism and chrismation, a newly baptized individual is to be communed according to the norms of liturgical books. So there could be legitimate reasons we can't do the first communion at baptism. We might not have the Eucharist, right? It could just be doing a hospital baptism and didn't have time to stop at the chapel beforehand, right? But generally speaking, that should be the normative practice. And in this case, we can see a legislative history established. We had the practice prohibited by the Ukrainian bishops in 1720, which was confirmed by the Roman Pontiff, received papal approval, had the force of law as it was issued by the Supreme Legislator. And then it's the Supreme Legislator who issues a law delegating the Synod of Bishops to issue this particular law in which they can find a suitable discipline. And the Ukrainian Catholic Church takes that norm and derogates from that papal law because they've been given that power. Now, what about a topic that's less clear, for example? So one that I will pick is the offerings for the celebration of the Divine Liturgy. Now, you have to be careful when we talk about money with priests, but in the Latin... He's close enough to kick me, too. No, in the Latin Church...
You're not getting any stipend for this talk.
Yeah, no stipend. And I always joke, as an aside, I always joke, I work for a Latin Archdiocese, so I'm like the best paid priest in the celibate wage is better, In the Latin Church, trafficking in mass stipends is a serious canonical crime. And what is trafficking in mass stipends? That's when a priest is making illegitimate profits on offerings for the celebration of the Eucharist. So you could do that in different ways. I could charge more than I'm supposed to be charging. I could not satisfy the obligations. I could farm them out to some priest in the third world who's happy to get $5, but I took $10 for that, right? You can think of all different combinations of this that does not reflect the basic principle in the church's canonical tradition that a priest receives a single stipend for a single intention on a given day. It prevents priests from celebrating 5 liturgies in a day, or 1 liturgy with 50 stipends, or from accepting dozens of stipends for a single liturgy, so different possibilities, as I mentioned. So a Latin priest, say in this archdiocese, I would hope, if he received, is $10 is the magic number in Toronto. A Latin priest receives $50, has to celebrate 5 masses, or could return $40, or could do 5 different ones at $10 a pop over a period of at least 5 days. Well, what about in the Ukrainian Catholic Church? What is a priest to do? What norms are present? I think generally financial concerns are I work in the chancery. One of the most frequent complaints, if someone's complaining about their pastor or the associate or whatever, it's usually something to do with money most of the time. And interestingly, the Eastern Code makes almost no reference to the topic of liturgy stipends. If you look at Canon 715, it says very briefly that it is permissible for priests to receive offerings for the celebration of the divine liturgy for the intentions which the Christian faithful make according to the approved custom of the church. So what is the approved custom of the church? You look at the particular law, and remarkably, there is no comment on this question of what is the approved custom of the church. There is absolutely no norm. So, say Father Alex receives $250 for a celebration of a divine liturgy. Someone's very generous. What do I do with that? Can I decide I'm going to do 5 liturgies at $50 a pop? Or can I do 1 liturgy and just take the whole amount? Or maybe 5 people want to give me $50. Can I do all 5 of those at 1 liturgy and take the $250? Is completely unaddressed in the current law of our church. And you can see how this could be prone to abuses, right? And really there's no there's no way for the bishop to track this stuff too, right? I mean, it's next to impossible to do that if you tried to enforce that. It's really, Judgment Day, right? That's the enforcement. There are no norms on bination in the Eastern Code even, right? So how many liturgies can one celebrate in a day? That's not addressed in the Eastern Code at all. Now, there certainly is, however, historical legislation, and the Synod of Zamość has extensive norms dealing with the question of the offerings of stipends for the celebration of the divine liturgy. I would expect 0 to 5% of our clergy have read them, but, they do exist. On the third title on the Eucharist, section 4, it indicates that it is not licit to accept multiple stipends for the celebration of the divine liturgy. A single liturgy satisfies a single intention. It's very clear in there. And maybe to mention, as a clarification, that we would distinguish between offerings for the divine liturgy, even the Eastern Code does this, and offerings for commemorations, right? That there's this distinction made between, this is the intention of the divine liturgy for which the priest is offering, and maybe there's like the spiskia, that have 200 names, and people are thrown in a buck or whatever. The Eastern Code distinguishes between those two, which is an interesting distinction to make. Anyways, in Canada, we also have the norms of the Ruthenian Church that were promulgated by Blessed Budka. And indeed, this also has very clear norms. First, a priest is allowed to celebrate 1 liturgy in a day in Blessed Nikita's norms. He can celebrate 2 liturgies on the feast of the Nativity, the Resurrection, Pentecost, in Theophany, but only if there will be enough people at both liturgies. He doesn't give a magic number, but says there has to be at least a need to do it. It can't just be that you want to have a second liturgy. In all other cases, the priest has to ask the permission of the bishop to have that second liturgy. In cases of bination, so when you have 2 liturgies in a day, you can't take 2 stipends. You get 1 stipend, the second stipend, usually the bishop would say, well, it goes to the chancery, it goes to the seminary, it goes to a poor priest, whatever. The priest can never receive 2 stipends in a single day in the norms of Blessed Nikita Budka. And this is just the same discipline of the Latin Church. So while the current law of the Church provides absolutely no direction on the issue, and I think could be prone to abuses as a result, the historical law of the Ukrainian Greek Catholic Church, which really is still in effect, provides clear norms to the contrary. And I think that's just but one example about how studying the historical law of our church can help identify some notion of ecclesiastical praxis and maybe bring order to chaos. Father Peter would often joke, if you don't like organized religion, you should become Ukrainian Catholic. And we, of course, have two dangers. One can be of creating a straw man out of history, right? Saying we dismiss it entirely as bad, whether it's Latin or Eastern or whatever, we just dismiss it and say we need to start anew. And maybe indeed sometimes we do need to start anew, but of course that always has to be a rational, informed decision as to, what was the praxis, and whatever the topic would be, what do we have as a legislation on the topic, and how should we revise it, right? And that requires an incredible amount of study to get to that stage. I appreciate that. We can also create an equally false image of history where I mentioned that we have these 3 conferences being organized on the Synod of Zamość, which is quite something. I don't know if we'll have 3 conferences organized on the 75th anniversary of the liquidation of the Ukrainian Church next year, right? I'm sure there won't be 3 conferences issued, which is just to see how some people cling to certain, I don't want to say agendas, but certain things in history. I think the reality is, however, that very few people have any knowledge really of these topics. And I think that's a real obstacle to renewal. How can one seriously study many of the topics of the life of the church without having any understanding of its history before the 19th or even the 20th century? And I think what's really needed is a monumental task, really a compilation of a corpus juris canonici of the Ukrainian Catholic Church, gathering all the historical legislation of this church in an organized and accessible manner. It should be noted, for example, that there really is no scholarly critical edition of the Synod of Zamość. I don't think maybe recently, but there's no translation in modern Ukrainian. I don't think there's Latin or in the old Ukrainian. There is now? Okay. That's
it's like 15 years.
Okay, 15 years. But still, 300 years took 285 years, right, to get there. So this is a monumental task to examine archival documents of our church, especially those which still survive, right? Our church has not had a great history in the last century, and that makes this kind of research even more complicated. But it requires to come to some knowledge of the canonical history of our church. And then once one such body of law exists, the corpus exists, then you can begin the actual process of codification, right? Well, what laws are actually enforced? What laws do we need? Do we want to get rid of half of this stuff? But how can you make those kind of intellectual decisions without even knowing what is out there? It requires that someone, in the Latin Church, we had this guy, Cardinal Gaspari, and he's like a 21st century Gaspar-Chuk or whatever, who can create a workable, current, and applicable body of legislation for the Ukrainian Catholic Church. Now, if you remember the Second Vatican Council, the defining marks of a church sui juris are liturgical, spiritual, historical, and disciplinary, that is, canonical, right? And we frequently seem to struggle with being able to agree upon every one of those 4 points at times as a church, right? And it would strike me, however, that the canonical identity of the Ukrainian Catholic Church is sometimes the most unknown. Something that would really ensure its proper functioning and provides a framework for all other aspects of its identity, providing boundaries where necessary, but at the same time respecting the legitimate diversity that certainly did exist in the Church of Kyiv, and I think, definitely still exists today, maybe a little too much. So how can one accurately observe one's rite when one does not even know, for example, if today, Tuesday of the 2nd or 3rd week of Lent, depending on what calendar we're on, can the Divine Liturgy be celebrated today? Because the particular law says one thing, but there are eparchies, I'm not saying we're outside the patriarchal territory, but in the patriarchal territory, there are eparchies that have explicitly said you can do it today, right? So, what is one to do? How can one complain that a priest neglects his obligations when there is no sense what they are? How can one pray a canonical obligation of his divine office when there is no approved liturgical text, right? There's no approved chasoslov that exists. The list can go on, and I think the canons have their ultimate purpose, the salvation of the faithful, promoting the spiritual good of the people of God, incarnate in a concrete church, in our case, the Ukrainian Catholic Church. And I think a greater knowledge of these canons promotes salvation of these faithful. And it's in a great project of examining these canons, especially as people here today who are scholars and leaders in that church, to make them available to those who, through no fault of their own, might be ignorant of their content. I didn't learn about any of this in my seminary formation. It was studying canon law filled in the gaps, and I took this great reading course, actually, with Father Nefetico, where we just read canon law stuff from the 13th century. And to make these things available to people who would like to learn those things, that we could promote this greater salvation to come. And I think also more fundamentally, strengthen the bonds of the identity of our Ukrainian Catholic Church. His Beatus Svetoslav is really promoting this idea of having unity in the church, right? That we are one church. We have one head. This year we're trying to get chrism from Ukraine, right? And it's not about the bishop being able to or not being able to do it. It's about being one church, right? United under one head, and trying to promote those bonds and having a sense of who we are. And I think canon law is a great step in that direction. And I'm exactly 1 hour there. So it's a little